ex-program manager at Endler, one of the world's top accelerator VCs, right? And then the following week, we have a pitch it session. So we'll be seeing some of our PAK challenge finalists actually pitch and get some feedback from our entrepreneurs and our founders that we have actually got on board for that session. So just a quick rundown of some other events. Oh, one sec. I think I need to clear this up. Okay. Yeah, so just a rundown of some other events. After the weeks on 5th October, during the PAK week, we have 3 back-to-back panel discussions. So one is the first one is about the new normal, the second is about fintech, and the third one is about e-commerce. So do stay tuned then. And finally, on 9th October, we have our PAK 2021, which is our virtual student startup conference. Just quick introductions about Rachel. So basically, our speaker today, we're really happy to have her. Rachel Wong is a startup M&A lawyer and founder of FoundersDoc, a legal tech startup that aims to serve early stage companies and founders in the Southeast Asia region, starting in Singapore, right? So FoundersDoc's mission is to provide easily accessible legal resources, quick guides and customized templates curated by lawyers for early stage companies in Southeast Asia. So personally, I actually saw FoundersDoc on LinkedIn, right? And if you haven't really followed FoundersDoc or follow Rachel on LinkedIn, please do so after the session. Her content is really interesting. It's really very digestible legal advice, not legal advice like per se, but legal content, right? That really aspiring founders, or even like early stage founders will find useful. So if you haven't done so already, I will urge you to and encourage you to actually follow her, follow FoundersDoc on LinkedIn. And without further ado, I'm going to hand the time over to Rachel and to kick off this masterclass.
Thanks very much, Clarence, and thank you, SMU Eagles, for having me. How much money must I pay you, Clarence, for getting increased followers on my LinkedIn profile?
No charge, no charge. Really, really great piece of content really, that you have really.
Thank you very much. And thank you everyone for taking the time off Thursday. You guys could have been going out clubbing, but you guys chose to spend 7 to 9 p.m. with me. So we'll try to make this fruitful. Feel free to turn on your camera if you want to. If you don't want to, that's fine as well. And I know some of you guys sent some questions across before the session, so I'll try my best to answer as many questions as possible. So I'm just gonna start by sharing my screen and then we can get going. At any time, if anyone has any questions, feel free to message at the message board, or just unmute yourself and speak if you're allowed to. So this is FoundersDoc. I'm Rachel. I'm a lawyer. I've been practicing since 2015, and in between 2015 and now, I had lots of friends starting startups. And I realized that there wasn't a lot of support for founders in Singapore. So a lot of lawyers represent investors and VC funds, but I didn't think enough lawyers were representing founders. So this year, I took a leap of faith and started a company called FoundersDoc, which is supported by a local law firm as well. And so far, the traction seems to be very good, and hopefully we can support more and more people as time goes by. So for today's journey, we're going to look through what a founder's perfect journey is like, right? So a lot of us will probably be at this stage called concept and research, right? So you think of an idea whilst you're asleep or going to sleep, and you're like, hey, I've got this great idea, and then you start committing of time and money on it. And then if you're a little bit more brave and a bit silly like me, you'll launch your company and get your company incorporated at stage 3. And then you look to see whether you have traction, you have more clients, you have more customers. And as your business grows, you get feedback from your clients and you refine the product. And then, hopefully scale and then become something like Grab. But this is like a very perfect picture, like a perfect marriage that you can ask for. More often than not, I have lots of friends coming up to me saying that they have experience some problems in their startups. So today we're going to walk through this journey with this hypothetical guy called Joe, who is a startup founder. I guess I emulate Joe after some of the friends that I have who tells me all their problems. So Joe is like passionate about changing the world. He reads Shoe Dog. Google story, super psyched about, the startup scene. And Joe has this idea in his mind. He's thinking about it every day. He's like, hey, I hate plastic pollution. I hate people like Rachel who use plastic bottles. Can we do something about it? And he's just, very passionate about this. And Joe came up with a great idea. He says, hey, why don't I create a mobile phone app so that, it's easier for people to recycle. Whenever they want to recycle, you just, take out this app, plug in something and someone will collect the plastic recycling materials. Plus, they get points for that. He thinks that that's going to be the next unicorn. How can anyone think that that is not right? So Joe has a good friend called Andrew. Andrew is working at Google and he is a coder, right? And then Joe also has a dad with perm hair like Phua Chu Kang. So he says, hey Andrew, hey, I got this great idea. It's gonna make lots of money. Are you interested in joining me as well? And then Joe goes up to his dad that has Phua Chu Kang like hair and says, hey dad, I got this great idea. Do you want to fund me? Because his dad has got a bit of spare cash, and dad is like, hey, yes, son, I believe in you. I want to support you. Let's do it. And then Joe also has a love of his life. So he wants to marry his girlfriend, but he also wants to do his startup. So it sounds like very exciting times for Joe. But as time progresses, right, some things start to change. When you first launch your startup, you're very happy, very excited. The world is your oyster. What could go wrong? What possibly could go wrong? So Andrew, who is Joe's good friend, gets promoted at Google, right? And he says, hey, bro, like, I got to spend more time at Google. I just got promoted. Salary is very good. And, my boss is like keeping track of my KPIs. And then, Joe's upset because he's like, I wanted to launch before Christmas because I wanted it to be a Christmas present for myself. And it's not happening because Andrew is not coding for me. And because Joe has been running on, his own savings plus the debt, the 50,000 that his dad loaned him, he sees his bank account going lower and lower and lower each month, and he feels kind of sad about it. Plus he bought the engagement ring very expensive, so it went even lower. So what do we think Joe could have done, right? What could Joe have done to prevent all these problems? So the first thing that we think he did and what he could have done is that, this is not a legal, strict legal point, but sometimes legal translates into, operational questions. Operational problems result in legal problems. So I always try to get, my friends and my clients to think about how to structure their product, right? So the first thing is that, Joe wanted to build an app to make recycling easy for people. But I think for most startups, you always want to look for the minimum viable product. Even if you're the richest person in the world, you want to do things from an MVP perspective, which is, what the Lean Startup book sort of like preaches, because you don't want to spend too much money or time in a product or service that, you have not proven that there's a demand for. So how could he have done that? I think from sort of like experience, an app costs sometimes 250,000 to build. But he could have simply done it using, let's say, Telegram channel or a Facebook page to figure out whether, people are interested in recycling. Would they, message this Telegram channel and say, hey, I've got plastic bottles to pick up. Will you pick it up for me? And I think one SMU startup did something similar, not in the plastic bottle space, but in the mini task space. And I thought that was really smart. You should always test your product, test whether there's a demand, cheap. Why this could translate into a legal problem? Because I see some of my friends investing a lot of money in a product, making the app look beautiful, and then there's no traction, there's no customers, and then they start fighting over, what went wrong. I want to sue my co-founder. So yeah, let's avoid these problems. And then the second thing that he could have done is enter into a simple co-founders agreement with Andrew. And this is a great sort of like we have a great recent story about this, which is one of our friends or client said, I have this co-founder who wants to join me. He's actually currently working in Google, and he promised me he's going to resign by this date. He just needs assurance. And once he sees once I give him the assurance that he's going to get shares and whatnot, I mean, we agree on a shareholding split, then he will come over, he'll resign from his job. So we prepared a co-founder agreement for them. And once he sent it to his friend then said, actually, I have cold feet, I do not want to quit Google. So sometimes getting people to sign a document kind of like either double confirms that they're on board with you or double confirms that they actually are not. And the second thing you want to have in your co-founders agreement is something what we call like a vesting schedule. So, if the person is going to be awarded, let's say 25% shares over time, then, it should be vested in the course of 4 years or 3 years or 2 years, whatever you guys agree. Why is this important? This is important because many a times with startups, co-founders sometimes change their mind. They have a baby, they want to get a stable job, and they have 25% of the shareholding stake, and they say, hey, I'm just going to quit, and I'm just going to leave. But if you don't have an agreement that says that, this is going to vest over the course of 4 years, then who are you to say, hey, you give me half of your shares back, right? Then he'd be like, we never agreed on a vesting schedule, so why are you asking for the shares back? Plus, I worked so hard for 1 year. So it's always good to put everything out in writing. It also makes sure that you think about how you want to collaborate with your co-founders as well. So on this note, I think one of the questions was equity splits. How should we manage the agreement, as well as how should NDA be crafted? So I'm going to answer the first bit first on equity splits. So a lot of co-founders like to do equal equity split. But that is also like the perfect way to get us engaged, because equal equity split, especially if it's 50-50, tends to result in deadlock situations. And generally speaking, a lot of investors like to see that someone actually takes the lead in making decisions and is the key accountable person. So to the extent possible, the CEO should have the lion's share. So lion's share ranges from like 60% to 90%. And then the rest is split amongst the other co-founders, like the CTO, the COO, and whatnot. And then I think there's this Korean drama called Startup, where they also discuss this point. So all the co-founders started off with equal share, and then the investor was like, hey, you gotta transfer your shares to the top guy, and then they got really angry. So it's a real problem, and it's best to discuss this even before everyone starts working on a product. So how can we manage the agreement? So the agreement will take the form of a co-founder agreement. How can I best describe a co-founder agreement? In my opinion, a co-founder agreement is like a short form shareholders agreement. And I know different startups start with different budgets. So I'm going to say a very non-lawyer thing of if you're really running on a shoestring budget, then, everyone here is well educated. Maybe you can just go online and download a template, or like, write down in plain English what you guys have agreed on. If you guys have a budget of 1 to 3K, where each co-founder maybe pays like $500 to chip in, then you can hire a lawyer to get a co-founder agreement in. But yeah, either way works, and that will depend on how serious you are about this startup. The third thing is Joe shared his idea with his dad and convinced his dad to lend him 50K to start his business. And then over time, the dad is like, where's my money, son? When are you going to give it back to me? Are you doing things properly in your life? So I think one of the best ways to handle like family and friends relationships when it comes to startup angel investments would be to enter into formal agreements with them. So at this stage, pre-seed stage, you can enter into convertible loan note, you can enter into a KISS instrument, you can go to VIMA SBCA documents and download the CARE document. You can also enter into a safe instrument. The only thing I would say is that the VIMA document has a most favorable nation clause. So unless that person's your dad, don't give him the NFN. What a most favorable nation clause means is that you always have to give that guy the best terms. So yeah, I tend to tell my clients to try to delete that. So Joe could have entered into a formal convertible instrument with his dad where he says, hey dad, this is a loan which I'll repay you in 2 years, so don't disturb me for 2 years, or which you can convert into equity. And that would probably also give his dad some form of assurance. In fact, the 50K would be enough for him to hire a lawyer to get a loan note drafted if he really wants. And then, immediate success is desirable, but not really realistic. So unless you are really a genius, or even if you're a genius, immediate success doesn't come early. So just plan for contingencies, plan for, things going not so much your way, and planning steps for success, right? So the first thing is to proceed methodologically. So when I started my startup, as with all entrepreneurs, you have to dive in logically or illogically and try something out. But you also have to give yourself like a time frame and some KPIs to meet. So for myself, I said, okay, within 3 to 6 months, if there's no traction, then I have to, maybe get realistic and maybe become a tai or something. But you have to have what do you call that? Achievable milestones as well as achievable KPIs and ways to assess whether something's actually working or not working. And that will give you a bit of sanity when doing startup is a very sort of like unclear path ahead, right? The second thing is plan effectively. So, have a roadmap of what you want to do when. You don't have to build the most beautiful product from day one. You just have to build a very simple product. It doesn't have to be the world-class app or the world-class website, but just something that's good enough for you to see whether, there's traction. So I think when I first started out, before I started FoundersDoc, I was thinking to myself, I want to build this very sophisticated marketplace and can match demand, become the Uber for legal and stuff like that. And very, very complicated. And then all these web developers quoted me, hundreds of thousands to build that app. And then I thought to myself, after many years of thinking about it, I was like, actually, all I need to test this demand is a website page. And I'm not as savvy as a lot of people. So I tried to use Wix, couldn't get a website out. So I just got someone to help me with my website development. And then, that sort of like store door was enough for me to test whether, there are people who actually want this. And, it seems like there are people that need startup legal advice. The third thing is find out what help is available. So depending on where you are in your stage of life, as well as, whether this is your first company or whatnot, there are incubators, there are mentors, there are resources, channels, and amongst founders like this circle, there's a lot of support for entrepreneurs actually. So don't feel like you're alone. And it's best to talk to people to figure out how their process was like and how you can sort of like mentally prepare yourself for it. So I think the number one thing is for a lot of startup founders, when you launch, you're like, oh my gosh, the world is gonna laugh at me, or they're gonna be so proud of me. I gotta make sure I do well. But the reality is many times when you launch, no one actually hears about you. So, don't worry too much. And then the fourth thing is, think long term. So, you don't have to do everything on day one. Just, plan things out slowly and do things in a milestone basis. So, as with Albert Einstein's quote, person who never made a mistake never tried. So we shouldn't be afraid of making mistakes, don't have to be too afraid of making the perfect product. And I would say you can also apply the same things to your legal documents. If you are really, really tight on your budget, then write it down in plain English, what you want to say to your friends or what you're trying to say. And once you've gained traction and whatnot, then get a lawyer to help you with your legal documents. For people who are trying out beta products, I think one of the key concerns that startups have is, what happens if someone sues me at the beginning because my product's not perfect? What you can do is, either have a big disclaimer like, hello, we are just, beta launch date and please do not sue us for that. Or indemnity letters, or, we will not, be responsible for any losses that you incur. You absolutely understand that this is just a trial product. So something of that sort could be helpful to help you sleep better at night. So these are just little simple tips to think about things. So other standard considerations that startups can look into are things like NDA. So I think someone asked, how should an NDA be crafted? If you really want, you can get a lawyer to draft the NDA for you. If you really do not want, you can go online and download NDA. What an NDA basically says is that, whatever information I share with you doesn't get disclosed to other people. But obviously the NDA has got to make sense. So it has to be either 3 years, 5 years, or perpetual. And it has to be robust enough. So you have to look at the scope of confidential information, and you have to look at the scope of permitted disclosures. When does an NDA really become important? It becomes important when, say, for example, you are sharing confidential information with people regarding the numbers you're trying to hit or the product or business plans that you have. That would be the case when you speak to potential investors and you share a deck with them. So NDA is one way of telling them that, hey, the information that we share with you is confidential, do not share with anyone. Obviously, also use secure networks to send your pitch decks if they're very confidential. So DocSend, Digify, all offer solutions for that. And generally speaking, I think I advise my clients to have two decks prepared. One with very generic information like who's the founder, what are our grand plans and whatnot. And then maybe a more detailed pitch deck that has things like all the detailed financial information, all the detailed plans that you don't want most people to know about. Only serious people will get the detailed pitch deck. So I think ways to mitigate sort of like leakage of confidential information would be a combination of legal plus things that you can do on the ground. The second thing is, I think what is most trending at the moment is online sort of startups. So add terms and conditions. Someone has a question over here that says, how does one ensure that the T&C-s and privacy policies are comprehensive enough? So generally speaking, your terms and conditions is a true reflection of how your business operates, right? And the main thing that your T&C is supposed to do for you is to basically say, I disclaim all liability, you can never sue me, there's a limitation on, how much damage you can claim from me. And it's just to manage your business risk. So I've seen many businesses launching without T&Cs, and it's a non-lawyer answer to say this, but I think it's okay at the beginning when you don't have too many customers and you just want to test an idea. So you can launch it without a T&C. But once you get to your 10th, 20th, 50th, 100th customer, then you want to start having a T&C in place because you want to manage your risk. At some point, you will meet a Karen or someone who's ridiculous and will just file a complaint or will try to make things difficult for you. So having those T&Cs will allow you to say, hey, look, these are the terms that you've signed up on and you cannot hold us accountable for that. Privacy policy is a requirement. So in Singapore, we have this thing called the Personal Data Protection Act that basically ensures that one, our personal data is handled in, or your customers' personal data is handled in a sufficiently robust manner that, we're not circulating all our clients' confidential information to Tom, Dick, and Harry. And the second thing is that there are obligations under the PDPA that says that you've got to tell users how you manage their personal data as well. So I think at the beginning, if you are really a micro startup, then you can start off with maybe very simple T's and C's and privacy policy that is in your own words. But when your business expands and grows, then the way I see it is that, the more customers you have, the more consumers you have, your risk and liability also kind of increases because your exposure to a potential Karen also increases. For the people who do not know what Karen is basically someone who just likes to complain about everything. So from that perspective, you need your T's and C's and privacy policy more robust as you do better and better. For the privacy policy, it's very important in some countries. So like in the EU, people get fined a lot because of breaches of personal data. In Singapore, it's more moderate, but it's still something that you have to keep an eye on. How definitely robust your T's and C's and privacy policy is will also depend on your business. So for FoundersDoc, a lot of people checked out our T's and C's. So even before I launched, I had to make sure that I had decent T's and C's, which decently had no typos. Otherwise, I'll get a lot of calls from people saying, hello, you have a typo there, formatting error there. The other standard considerations that we would say are things that people should think about at the initial stages would be, as your business progresses, you're going to have employees. So in Singapore, actually, interns are actually also employees, part-time people are also employees. Only independent contractors and consultants are not employees. So as your business grows, then you would have to enter into an employment agreement with people, including the co-founders. So what the employment contract does is, number one, it sets out the key employment duties of the person. So, you have to devote some time to our business. You cannot you cannot surf too much Facebook during our working hours. Second, which is quite important for a lot of companies actually, is the termination provisions. So everything will be happy in day one, but sometimes you will meet employees who do not perform or, are causing a bit of trouble. So what are your termination provisions? Why this is important is because there's this statutory board called Ministry of Manpower, and if people are unhappy, then they'll be like, I am going to complain to the MOM. So if you have clear termination provisions, then you can say, hello, I'm just following the contract. The next one is confidentiality provisions. So with startups, you have competitors, and you have, people who are trying to do something similar. So the last thing you want is you want your employees to go and tell your competitors that, next month they're going to launch this product, next year they're going to do this. So you want to make sure that your employment agreements have robust confidentiality provisions. The next thing you want to have is IP assignment clauses. So you want to make sure that it's very clear, black and white, that all the IP that's created, all the wonderful things, all the apps that you produce, all these ideas will belong to the company, and the employee cannot run away with these ideas. And maybe you may also require a non-compete. So non-compete is one of those slightly controversial provisions. In Singapore, a non-compete is only enforceable if it is reasonable. And what is reasonable depends on the person's rank. seniority, and scope of work. So put in a non-compete, but just make sure that it's reasonable, that if someone doesn't work for this amount of time, that it's actually or a fair ask from them. A good employment agreement would be a requirement that more sophisticated investors will request for before they invest in your company or shortly after they invest in your company. And then the next thing is ESOP. So actually I had a lot of questions from you guys on ESOP. So with startups, your main draw or pull for other people would be the fact that they can own a bit of your company and hopefully retire early. So an ESOP comes in very handy for startups. It serves two purposes. The first thing is for employees to be incentivized to work hard, right? And the second thing is with millennials, our turnover rate is very high. So if someone has ESOP, then maybe they'll think twice about leaving your company. So I'm going to answer the first question, which is I am not sure how ESOP works. Would love to understand the topic better. So how an ESOP works is that you grant employees a share option, or you can also grant advisors or consultants a share option. And then you say that, okay, let's say, for example, I grant an employee 100 share options. Then I say, okay, I hereby grant you 100 share options that will vest over 4 years after a 1-year cliff, for example. That means that after they have worked with you for 1 year, then they'll have 25 shares and they can say, hello, I would like to exercise my share option and convert the option into shares. At this stage, different companies have different requirements. So some companies will say, okay, I'll give you shares for nothing, which is like maybe nominal sum like $1, $1 for all the shares, right? But other companies will say, okay, I will give you shares at a discount price. So maybe I'll give you 50% discount. So the current market value is $50 per share. You can subscribe to our shares for $25 per share. So how do you know which one to choose? It really depends on one, you have to look at your employees and see whether they are able to pay for those shares. So if they have to subscribe for 100,000 shares at $1 per share, I'm not sure how many people will have the 100,000 to put in. For some startups, they will have to go for the $1 option, for $1 for all the shares option. For other startups, they actually know that they're employing people with a bit of money and they want to make sure that those guys also put in money in the company. So they will say, okay, I will give you a discount. So whether or not you have an ESOP with a high exercise price or a nominal exercise price will depend on where your company is, who are you hiring, and whether they have a bit of cash to underwrite it. After that, they will be issued shares. But in order to implement the ESOP itself, you need to have ESOP rules, ideally, and you also have to pass a board resolution and shareholder resolution for that. What does the ESOP rules set out? The ESOP rules set out things like if the board wants to change the ESOP rules, they can change it, right? Why do you have to change the ESOP rules? Because, Series A, B, C, D, E, more investors come in, your business changes, so you have to amend your ESOP rules sometimes. Second, you want to have this clause inside, which is the good leaver, bad leaver provision. So if someone leaves for a bad reason, you want to say, hello, give me all my shares back. If someone leaves because, their wife got pregnant and they find a stable job, then maybe you can do it under the good leaver provision and they can hold the shares that are vested in their name. The third thing you want to do is to account for things like accelerated vesting in the event that there's a liquidity event. So if someone wants to buy you guys out, then how are you going to deal with it? So you're going to address it. If someone wants to buy you out, then Is there a drag along clause to make sure that the employees who have been awarded shares will be pulled along as well? And also think about whether you want to give your employees voting shares or no voting shares. Because if you give your employees voting shares, then at every shareholder meeting, they will also be entitled to vote on the matters as well. And sometimes it's a bit weird, you're the boss and you got asked them permission about a resolution. So yeah, things to think about. So answered the first question on how does ESOP work, and would like to understand that topic better. The other question is how do we set out our employee share option pool? So, as mentioned just now, you need ESOP rules, you need board resolution, you need shareholder resolution. And then you also have to think about how big the ESOP pool is going to be. Typically, it's 5 to 15% of the total share capital, assuming your total share capital is not 1. And it's good to have an Excel sheet that plans out, that sets out how many shares you have allocated to each employee so that, everything's good and in order. Once you get to a stage whereby you have a lot of employees, you might want to use a SaaS provider like Cake or Kata to help you with the ESOP pool management. So we have answered that question. Okay, next one, advisors agreement. So for a lot of startups at the beginning, it's nice to have mentors or people who are vested, who have a vested interest in you to make sure that you do well. So a lot of people enter into advisor agreements with, key individuals to make sure that, they have a good contact or they get the right steering and direction without paying through their nose. So it is good to enter into an advisor agreement that either sets out their cash or equity consideration, but what is key in the advisor agreement are things like, similar to the employment agreement, making sure that they don't leak your information, all the IP remains with the company, and they cannot do things that is in conflict with your company. So the key difference between employment agreement and advisor agreement is an employment agreement literally sets out the rights of an employee and employer, versus an advisor is not an employee. And the document will look a little bit different from the employment agreement. So these are the standard considerations to look at. And at this stage, let's see whether anyone has had any questions so far. But I've got more questions that I think I have to answer on my list.
Hi, so is it free for us to ask questions now?
Yeah, anyone can ask questions. And if no one asks questions, then I think I have 10 more questions to answer on the list.
Yeah, thank you, Rachel. I think your presentation is really informative. Just now you mentioned that it takes like hundreds of thousands to build an app, is it?
Oh yeah, I mean, that was what the tech providers quoted me when I was going to build my app.
Right. So in the end, when you build your website or app or what, how much do you fork out in the end?
For my website, I paid 3,000 plus. Yeah. But then when you build a website, you have to think after you launch your website, you have to put in marketing costs, in the sense that search for the search engine to locate your website. You have to put in like extra money to make sure that whenever people Google something, your website comes up. So all in, I would say was like 5K for me. For a lot of my friends, they use like Wix or Squarespace to do it. But I think when it comes to the search engine optimization, they still had to outsource it. And I think you can get someone from Fiverr or one of your good friends to help you with the SEO bit. Yeah.
Right. So would you recommend maybe certain things that we can do to mitigate the risk, especially if we want to build an app that costs a few 100,000?
Yeah.
So thinking of maybe like progressive payment upon certain milestone being hit or something.
Yeah.
What would you recommend? Thank you.
Yeah. Good question. I would recommend not spending a few $100,000 on the app at the beginning, because I have a starter client that spent a few $100,000 on their website and app. I think like 500,000 or 800,000, something like that. And then after they built the app, they realized that there was no traction. So I think my if I could share would be, don't spend a few $100,000 on the app at the beginning. Just do a very simple like website, or try to use creative methods to test out the demand. Yeah. And then when you do employ someone to do your app, then that web developer should already have like either their standard terms and conditions or whatever, or whereby it's usually quite clear for website developers. Whenever they reach a certain milestone, they need to pay more money. So let's say like 25%, they start building a website, then to do the UI or to design a website, and then when they want to start coding, then they will ask you to pay more money. Then after they complete, then you pay more money, that kind of thing. So tranche payment is quite useful. Yeah. Any other questions? Otherwise, I will answer some of the other questions that I received. Or if you don't dare, you can also like type it up as well. So I think someone asked, the ACRA only has 3 names, but we actually have 4 founders. What should we do? So the first question, I'm not sure whether the person who asked the question is here, but the first question I'm going to ask is, where does the 3 names sit? Because on the ACRA, there are 2 main things. One is your shareholder, and one is your board of directors. So by right, if you have 4 founders and you want to give them board seats, then it should be 4 directors. Then what you have to do is appoint the 4th person as a director as well. If you have 4 founders, but only 3 names on your shareholding table, then you need to issue shares to the 4th person. And then all you have to do is either tell your company secretary or whatever smart person that did the ACRA stuff for you to update the ACRA. So it's quite administrative point. But what should you do? You should enter the co-founder agreement, because 4 founders is a lot. The other thing is, within 6 months, you have to appoint a real company secretary. So do budget for that. In Singapore, you have to appoint a qualified company secretary. Okay. Hope everyone's not asleep yet. If you're asleep, then ring the bell. The next one is, when handling a B2B platform, what are the most important legal issues to look out for, and how to protect ourselves against those issues? So I think that's quite a broad question, but the main legal issues to look out for, number 1 is, I think, if you don't have a contract, I think that's if it's a B2B arrangement, if you don't have a contract, I think that's an issue, because it's your word against my word, and there's no proper arrangement. So even if you draft your own contract, it's better than no contract. The second thing is, look out for things like indemnity clauses, right? So if there's a huge indemnity clause or high late payment interest clauses, those are things that you kind of don't want. The 4th thing you want to do is to limit your liability. So that by right, there should be a limitation of liability clause that says that you will not sue me for everything that goes wrong. And the 5th thing to look out for is just to think about what this B2B transaction is about, and then what is the worst thing that could go wrong. So for example, like in a distributor agreement, the worst thing that could go wrong sometimes is like, there's Hurricane Katrina and all our goods are lost. So in those situations, who's going to bear the risk, who's going to bear the responsibility? So these are things to look out for. But if it's, let's say, like a influencer engagement, like your company is engaging an influencer to promote some products, then the worst thing that could go wrong is the influencer, you know, posts a naked photo of herself, and then after that, you know, it has a bad reputation on the company. Then you want to have the ability to make sure that the influencer, whilst they're promoting your product, has certain clauses that says that they're gonna behave properly, promote the thing in the right manner without, you know, with how many posts, how many words, whether you need to approve the post or not, whatnot. But I think one question came in, which is okay, so I guess this question came from K1. All three of us sit on the board of directors, but we can't list one of them as he's holding an EP from another company. Got it. So I think it's okay for him to just be a shareholder, but maybe at some point in time enter into, I mean, if he has an EP from another company, that probably means that he has a real full-time job, not real full-time job, but a on paper full-time job. So I think maybe having a co-founder agreement could be helpful. And I'm not sure whether his EP allows him to hold shares. So maybe he can at some point in time hold shares in the company as well. But with 4 co-founders and with 1 co-founder at least not being full-time, then it's good to set out everything in paper and just, you know, or maybe just like a table format or something that you guys agree who's going to contribute what and what you guys are going to do, who's going to put in money and stuff like that. Yeah. Yeah. You can just put like an email or something at the beginning, you know, or something, just to make sure that, you know, he doesn't get free contribution or whatnot. But yeah, can make it all friendly, but just document everything. Okay, another question is, how can you most efficiently understand if your idea is novel? Okay, back to the, now I'm thinking about it. Back to the 4 co-founder one, please do not do 25% split. Try not to, yeah. The reason is because in Singapore, you need more than 50% to pass some shareholding resolutions, more than 75% to pass some shareholding resolutions. And for board resolutions, if there is no shareholders agreement, then it's like 1-for-1 vote. So you don't want to get into deadlock situation. So maybe get the shareholding profile to reflect how it really is. Like the CEO has the most, and then you guys have some as well. How can you efficiently understand if your idea is novel and can be patented? So this is actually quite like a straightforward question in some way, in a sense that you just have to wait to the patent guy, and then the patent guy will then file a patent application for you. And if it can be patented, then it will be patented. So it's actually quite a straightforward question. So that for my startups, like there is this cheap patent guy in Malaysia. So I always like flick them across and say, can you guys help them with the patent? The patent is actually quite expensive. So I think one lawyer whom I respect and I like said something like, oh, don't invest in startups unless they patent their ideas. But in my mind, I'm thinking like patenting an idea is very expensive, actually. So for me, because like I care about like the startup's money a lot, so I'm like, okay, maybe they should only need to patent the idea. Number one, if it's really, really like highly patentable. And the second thing is where maybe after they've raised some money from investors, then they go and patent it. I think it's like the applications can be quite expensive. Yeah, so just do things in step-by-step basis. I do not know whether I can mention names, so I'll just say someone. Someone said, how do you balance your career in law with your startup? And what do your law firm supervisors say when you let him or her know of your outside commitment? So for me, I started off with big law firms. And the reason why I left was because the big law firms, like the starting ticket size is very big. You know, it's at least tens and tens of thousands before I can onboard them. So I wanted to set up a structure whereby I can start servicing my friends. So I started my own, I was going to start my own law firm, but then my good friends at Eugene Terasingam, they said like, oh, why don't you park your practice under us? So they knew about it even before I started my FoundersDoc, and it was like a condition for me to do it whilst I also are with them. So they're fully on board with the idea, and they knew I was going to do it. And from my perspective, it's like both is the same thing. Like my practice under Eugene Therasingham and FoundersDoc is the same thing. It's just branding is different. And whenever our clients run into conflict issues, then we park it under Eugene Therasingham. But I didn't really balance my career in law with my startup because I'm doing both. So, yeah. But they are like the same thing to me. So yeah, if let's say, for example, I am in a full-time job that doesn't allow me to do FoundersDoc, then how would I do it? For me, because I'm in a regulated industry, which is legal, so there's no way that I could have done FoundersDoc on the side. So I knew from day one that if I did it, I would have to do it full time. And I have to be very open about it. And because it's a regulated thing, so you have to make sure that you're fully compliant, that you don't piss off anyone too badly. So because I'm in a regulated industry, I was very, very careful, and I made sure that whenever I give out legal advice, I always have a practicing certificate, and nothing is too like, wishy-washy or whatnot, and no one hopefully can, complain about me and whatnot. So because I'm in the legal industry. If you are not in the legal industry, you're not in a regulated industry, then I guess a lot of people start their full-time job doing something from 9 to 6, and then after 6 p.m. they start doing other stuff. But what I would say is it is good and useful to maybe do a bit of preparatory work before you actually like resign, because it makes you feel much more comfortable. At least for me, if you've done your homework and you've done like some thinking and you thought it through very carefully, then when you do your startup, you don't feel so like, am I being crazy or something? Yeah. So I think preparation always helps. I'm going to answer a next question, but feel free to ask more questions. What are your proper steps to get registered and get funding? To get registered, it's super simple. Just go to ACRA and get your company registered. To get funding, it's not so simple. I think a lot of startup founders have to pitch to a lot of people before they get funding. But then once they get their first like key investor in, then everybody wants to fund them. So all the people that I see who say they raised 6 million, they raised 10 million, I personally know that they pitched to hundreds and hundreds of investors before they got their first money in. So, perseverance, and then having sort of like belief in yourself is important. And then have a very strong like co-founding team. So, for startups, you're really pitching an idea. So when investors invest in you, they believe in you rather than the company. So make sure that it's a very strong co-founding team and that your pitch comes across as a very sensible idea. And if your idea is sensible and your mom approves your idea, then you shouldn't be afraid of pitching to as many people as you want. And then maybe give yourself like 6 months to get your money in. But yeah, don't give up. And then I think for me, like FoundersDoc was an idea that I had in my head for about 3 years before I actually launched it. So if you really want to do something, then it wouldn't get out of your head anyway. The next question is, what is the best way to draft a shareholders agreement? So a shareholders agreement, in my opinion, is one of the hardest documents to draft. So I would say that at the beginning, you can draft your own shareholders agreement, but at some point you want to clean things up and get it cleaned up by a lawyer, law firm. Why is a shareholders agreement very complicated? A shareholders agreement is like, it's like your marriage proposal or something. It's like, it is forever, as long as you guys are shareholders. So you want to make sure that everything is very clear, because if it's not good, then what you're going to get into is you're going to get into a shareholders dispute, which is going to cost more than your shareholders agreement. So what a shareholders agreement should cover would be things like board appointment rights, like who can appoint, which shareholder can appoint board. Second would be for shareholders, right? Is there going to be shareholder reserve matters? What would the quorum be like? Quorum means what is the minimum number of people for you to have in order for a meeting to be present, like valid, and then your voting rights. So how many people must vote and who must vote in order for something to pass? Under the basic law, it's 50% for most things and 75% for very important things like changing the constitution. But sometimes it's good to have a shareholders agreement to set that out even more clearly. For example, if you're the CEO, you don't want your entire company to 造反. 造反means, rebel, and then like vote something against you. But these are just the very basic things, right? The more important things is share transfers. So you don't want your co-founder to transfer your shares to a competitor. You don't want your co-founder to mortgage the shares, with the bank or something. So share transfers have to be regulated. Share issuances have to be regulated. So whenever you guys issue shares, how would that look like? What will happen if someone doesn't subscribe for shares? And how are you going to, you have to include things like tag along and drag along rights. Why? Because let's say, for example, someone wants to buy your company up one day, they wouldn't want to just buy your shareholding, they want to buy the entire company. But if other people hold shares, then you need them to agree to it before they can sell the company. So that is why a drag along clause comes into play, because it basically says that everybody has to sell if certain thresholds are met. That allows people to exit. Where does the disagreement come from? The disagreement comes when three people want to sell, then the fourth person is like, I don't want to sell because the price is not high enough, I'm not happy. You guys work for a higher price. So then when you go to be investing, you're like, okay, I can sell 90% of my company, but I can't get a 10% guy to sell. Then the guy is like, I do not want to buy a company that only has 90% equity, that I have 90% equity inside and to do with this 10% shareholder. Then people will start quarreling. Yeah. So that's how quarrels start. So having all these clauses in with the end in mind kind of helps. But as I mentioned, don't have to get into a complex shareholders agreement from day one. Maybe get into it maybe after 1 year of operations and you guys are actually making lots of money. Then you're like, okay, time to get the house in order. To get a good sense of how a robust shareholders agreement looks like, you can go to SVCA BIMA and then you can download the shareholders agreement. But if you don't understand what you read, then don't sign it. So I don't understand the shareholders agreement when I first graduated. So maybe you guys are smarter than me, but just don't sign whatever you don't understand. Okay, best way to draft a shareholders agreement, get a lawyer to draft. You don't otherwise you write in bullet point what you guys agree, and then after 1 year get the lawyer to draft it for you. Or you're going to be really cash prudent, then get a advisor who's a good lawyer, who's a corporate lawyer, to draft the shareholders agreement for you, and then you say like, hey, I give you advisor shares, can you draft it for me for free? But I do not know how many lawyers will do that. Okay. Okay, this is a question from Timothy, since he said to everyone, so I can say his name. Just curious to find out what you've seen on the ground since you started FoundersDoc. How big is the information gap there is with startups with respect to legal matters, and which point should founders start thinking about legal matters along the journey? That's a good question. The first one is, how big is the information gap among startups to legal matters? I mean, I think for a lot of startups, there's obviously a huge gap because you guys are good at operating the company. So you guys are good at what you guys are good at. And then I don't expect you guys to know legal stuff. So one of my good friends started a startup, which did very well in the end. And he's very smart, from Ivy League and stuff like that. But when he looked at shareholders agreement, he was just like, what is this? How can I understand it? I don't understand it. There's not enough resources. So, I remember listening to that situation, and I'm just like, if someone who's intelligent by a lot of standards is struggling with understanding a shareholders agreement and he feels that there isn't enough resources out there to help him understand it, then there's definitely information gap. Yeah, so I think part of my what I'm trying to do as well with FoundersDoc is we try to release a lot of guides so that you guys can at least have a basic understanding of what are the legal things, so that you guys know what to watch out for, and when you kind of smell that things are not right and you need to get like a lawyer on board. And so to answer your question, there is definitely a big information gap, not just with startups, but with a lot of things, because I think the legal industry was traditionally very conservative, and they only publish information using long articles or long textbooks. So yeah, so I think part of my campaign is to make it more accessible. And then at which point should founders start thinking about legal matters along their journey? This one really depends on the kind of founders being on board. So currently, a lot of our clients are in their mid-30s, and then they are starting their startup with a lot of rigor to make it the next unicorn. So from their perspective, legal is important from day one, because they have risked a lot. They have gotten a lot of important people on board, and they want to make sure that everything is done right. But then if the startup is, let's say, like, maybe out of university, we also have some clients who are just out of university, but if it's just like a very preliminary project that you guys are thinking of, then I don't think it's that, like, legal shouldn't be your number one priority. Operations should be your number one priority. And after you've sorted out your operations and you get customers, consumers, the business actually is growing, then you have to sort out your legal. So I say legal is proportionate to your potential revenue and your potential growth. And obviously all of you guys will do very well, but I don't exactly want people to spend too much money on legal even before they get going. Similar to how I don't think you should be spending hundreds and thousands on an app even before you prove a product. So same analogy. Next one is, I think, quite similar to this question actually. How deep do we have to go into law as entrepreneurs without much financial backing for legal affairs of the business? Hopefully at some point in time, FoundersDoc will have enough resources for everyone to have a bit of basic legal understanding. But I think that as entrepreneurs, you can focus on what you're good at, which is operating a company, finding the right people to help you grow. Maybe even if you have lawyers, it's good to have a basic understanding of what you're signing. So like in the case of my friend, he had lawyers, but he wanted to understand the shareholders agreement to understand what he was signing and whether it was in line with what he wants to do in future. And why would that be helpful? Because I don't think all lawyers will look at things from a commercial perspective, and sometimes we don't know what you guys want to do in future. So we don't know sometimes how that clause would impact your future growth. So sometimes having a bit of like general knowledge about everything would be helpful. To take an example would be like there is this investor that's trying to negotiate for a co-sale right. So he wants to say that whenever the founders sell shares, then they are going to have the right to sell the shares together with the founder, right? Which is whenever the co-founder sell shares. So I think without really thinking about what you want to do with the company, you'd be like, oh, that sounds reasonable. When I sell shares, then the investor can come with me. But for quite a number of the startups that I know, they like to raise money in between rounds. And sometimes they may not be able to issue more shares because their current investors say no or whatever. So they want to sell their own shares. So in those instances, wherever you sign a contract saying that whenever I sell shares, I have to give my investor the right to sell their shares to that person as well, then it's very hard for you to pitch to an incoming investor, because incoming investor will be like, okay, when I buy your 100 shares from you, there's a possibility that I have to buy the 500 shares held by your investor as well. So for some of my clients, they're okay with that. They know that they never want to do it. But for some of my clients, they're like, there's a huge possibility that we're going to transfer our shares as part of our fundraising. So that will be an important carve out that we want. So yeah, so I think just like how I, as a very like non-financial background, bad with Excel sheet person, I have to force myself to understand a bit of financial statements. I guess it's nice for you guys to know a little bit about law as well. And then the last question that I have on my list is there a source or website where I can learn how to draft an employment contract in Singapore context? You can learn how to draft an employment contract with an internship with a law firm. Yeah, but I'm not sure whether there are draft employment contracts released on online or websites. I guess like if you guys are at very, very preliminary stages of your startup, then I guess like Zigo and stuff like that could be helpful, because I do think they produce M1 website. I don't think they have employment contract. I don't think so. Yeah, so I guess like platforms like Zigo with a subscription fee can be quite helpful. But then I think as your business develops, then your employment contract will look quite different. So I think for us, we also have an employment contract that we have, but all the employment contracts that we've issued to our clients have kind of look quite different, because every startup has different requirements. Like a tech startup will have a different set of consents as compared to, let's say, like a personal training company. So the employment agreements will look a little bit different. So I think that's it for me. And then I'll pass the floor over to Clarence. And I think all of y'all can go out clubbing, because I think we ended a bit early.
Yeah, Rachel, maybe can I just ask one question on an earlier point that you sort of like touched on, right? Just now you were talking about company secretaries and things like that, right? So I think I have two parts of this question. So one part would be like, how important it's like for early stage founder, or like maybe a founder who's really just starting out, right? To I guess address this point where they have to get a company secretary. There are so many like startups that's doing this right now, right? Like Slate, like Awesome. How important is it to actually probably use these services, or could you do it yourself, right? And yeah, is there anything to take note in that sense, yeah, in that respect?
Yeah, if I'm not wrong, you have to hire a company secretary within 6 months, so that's compulsory. I mean, the downside if you don't have it is that you kind of get a fine from ACRA, I believe.
Right.
Yeah. Which is automatic. So once you register a new company secretary, they automatically fine you. It's a few $100s. Tend to be that time. And that few $100s will probably be more expensive than your company secretary fees. And then the second thing is you have to be qualified to become a company secretary.
Right.
So not everyone can be a company secretary. So I think there are a lot of cheap company secretary providers. Obviously, off the record, if you guys want to breach it, then you just pay the fine. But maybe a smarter way would be to think carefully before you incorporate a company, because winding up a company actually costs a lot of money as well. Like, it's not that expensive to set up a company, but there are two ways to get a company like off ACRA. The first way is for it to be so dormant for so long that ACRA strikes it off, which is like so long. The second way is to apply to wind up the company. And I believe the entire process is very long and quite expensive, like $10,000 sometimes.
Right.
So I think that maybe the smarter way is to not incorporate a company yet until you guys have decided to do things correctly.
Yeah, I think that really made a lot of sense, right? I think something I wanted to ask as well is maybe just to recap everything that you have just said, right? like even your presentation. Like so if there's those new founders in this among the audience here, right? Really thinking about starting up, really thinking of going through that motion of like incorporating, trying to do a shareholders agreement, trying to do a co-founders agreement, things like that. So what is the one thing that you want to tell them, to make sure that they cross their T's and dot their I's, and all the checklists that they have to do before they even like incorporate or things like that. Yeah.
Okay. I mean, that's a pretty good point. Maybe I should issue a checklist for startup. I think the most important one when everyone starts would be probably if you have more than one founder, would be the co-founder agreement. It can be as simple as bullet points if you guys are not at the stage whereby you guys can hire someone. But co-founder disputes is one of the top things that comes to me. And it is not nice by the time it comes to me. So I think the co-founder agreement would be something that people should think about. And also, once you guys issue shares, just note that transferring shares is very difficult. You need both parties to agree. Getting rid of a shareholder is very difficult. It's like perfect for shareholder dispute. And all these disputes are expensive. So just, I would say like at the very beginning stages would be the co-founder like understanding amongst each other.
Right.
I see Evan has turned on his camera.
Hi,
Great.
Rachel. Hey, thanks for sharing so much. I learned quite a lot from you.
Great.
Sorry. So for my startup, right, we created we didn't get a lawyer to do our terms and conditions or private policy and everything. We just go to our competitors' website and copy them and change the name. Is that okay?
So I mean the technically correct answer is plagiarism, but yeah, I guess sometimes I see people doing that. Yeah.
So should we like start getting a lawyer to
I
review
think
it?
yeah, maybe like down the road when you guys have more customers, then maybe just like review it. But hopefully your competitor pay a lawyer for that, and then you have to just change it.
Yeah, we even got a friend from like I think NUS Law School to help us vet through. Yeah, so that's all we had. So even our
Yeah.
founders agreement, it was also like through online, and then we just changed things. And
Yeah.
we
I
straight
mean,
up-
like I think at the beginning, like when you guys are pre-revenue or whatever, then can go with this, and then when you guys get along when you guys start earning like 100,000 or whatnot, then maybe it's time to say, okay, let's maybe get the house in order, just in case something goes wrong next time. Yeah. On the T's and C's off record, I think it's the competitor one is per a good benchmark. Yeah, good benchmark. Just make sure that
we just
it's
like open 5 competitors tab, and we just look at all them and combine them together.
oh yeah, okay, yeah. Then that one could be called what we call rojak. So yeah. So I think yeah, maybe like at some point in time, once you become a sophisticated business, you also at some point in time have a general counsel, right? So I think for now it's okay. Just the only thing is for terms and conditions and privacy policy, that is also something that I look at before I decide whether I want to go public with a partnership with someone. So there were a couple of companies whereby they said like, oh, can you announce that we will be keen to partner with us? But then when I looked at their website and their T's and C's, right, then I'm like, okay, I cannot partner with you because you guys clearly haven't cleaned up your T's and C's and you guys do not look legitimate. So I think maybe a nice time to clean it out would be before you guys go to investors, or maybe you guys already have investors, but once you guys go to institutional investors, then they will start doing a bit of due diligence, and then they will ask you to enter into formal employment agreement and whatnot. But optically, from an investor's standpoint, if they're institutional, it looks much nicer for them to see like, oh wow, this person actually got their house in order. Yeah.
Okay, got it. Thank you.
Yeah, all good.
Does anyone have any last questions for Rachel? I guess if not, thanks everyone for joining us tonight, right? Maybe after this session, drop by Rachel's LinkedIn, drop by FoundersDoc's LinkedIn, check out her material, her content. Trust me, you won't regret it. It's really simple, very easy to understand, and it's really cool stuff, right? So go do that. And maybe Rachel, how can actually people just connect with you? Should people connect with you on LinkedIn, on Facebook, or Instagram?
Yeah.
Or yeah.
LinkedIn is great. Yeah. I mean, I try to be quite active on LinkedIn, so feel free to connect over there. And then, yeah, like, we want to try to increase awareness on what founders can look out for without them paying through their nose. So, insofar as we can release guidance notes and whatnot for people, then we'll be more than happy to do that. And then as startups, we also do not want to see you spending too much money on legal unless you guys have either gotten traction or are yourselves like experienced co-founders. So we also don't. I sometimes tell my client like, you don't need this document, so don't ask me to draft it. So yeah. So yeah, it's kind of like sometimes people are like don't want to pay any money for legal, and then when they got a problem, they're like, why is this a problem? Like, look, yeah. So it's just like, any tax consideration should bear in mind. I'm not a tax lawyer, but I think last question from Jerome, direct message to me. Am I supposed to say your name? I'm sorry. Would be okay. So basically, I got a question from someone that says any tax consideration we should bear in mind. I think Esop is a tax consideration for some people, but for some of my friends who are US based, what they did was they issued a lot of shares and paid tax on the nominal value of the shares when the company was worth nothing, because in the US the tax is quite punitive. In Singapore, I think there's tax as well, but I think it's less punitive. But I would say, yeah, if your company is still negative NAV, then you are still you don't have to worry too much about tax yet. Once you're raising your fund, raising money, and you have a valuation tag to your company, like, oh, we're raising money at X amount of valuation, then yeah, maybe it's also timely to just get a cheap tax advisor and say like, hey, or maybe you can pay your friend coffee money and say, can you tell me what I should look out for tax? Yeah.
Okay. I guess if there's no other questions that is PM to Rachel, I think we can call it a night. Maybe just everyone can do like a virtual round of applause for her. Thanks Rachel so much for your time. Could I just get Rachel to could we just take a team photo like among the Eagles team just for the next 2 minutes, right? But I think for the rest of the attendees, you're free to go. Thanks really so much for coming down, listening to Rachel asking some questions actively, things like that. Yeah, and so thanks everyone for coming down. Rachel, if you could just wait like 1-2 minutes so that everyone can just exit the room, we can just take.
Oh, why don't you join the photo, no?
Yeah, I mean from previous experience, I mean some of the folks who just want to live, it's fine. Yeah, we don't want to force any kind of photos on people. So yeah.